What's up, everybody? What's up, everybody? Welcome to the live. Shout out to the playback crew on YouTube. Everybody say hi. Say hi. Hit the like button. Let the algorithm know that we are here. We are going to go over some Young Thug trial updates. Remember, we are all back in court. They are all back in court on Tuesday, July 30th. That's next week. So if you're looking for new updates, new video clips, we don't quite have those, but we have a slew of new filings. Somebody says on TikTok, hello, Queen Zero. Hello. Thanks all for the love and for tuning in. We've got a few motions to go over, and I'm going to do something else tomorrow with Doug Weinstein, Deamonte Kendrick's lawyer, and hopefully have some other interviews lined up later. But remember, they are back in court next Tuesday, the 30th, to start deciding some of these motions that are being filed. We've got motions for bail. We've got motions for mistrial. And interestingly, the prosecutors are filing their own couple of motions. And one of the motions is them basically just complaining about the media interviews. They want basically a gag order in place. And they're citing, there's a Georgia rule of professional conduct saying that lawyers aren't supposed to make statements that they think will influence the proceedings. And they're citing Doug Weinstein's interview with me, infamous Sylvia, Max Shard's public statements, his interview. They're also citing Brian Steele's lone public statement. I mean, he just issued one public statement regarding the recusal of Judge Glanville. He hasn't sat for an interview during the trial, but they're complaining about them. We can bring that up here. That's probably the least consequential in terms of the actual substance of the trial, but it's probably the most interesting to me. I can't imagine the judge is going to grant it. I mean, it's basically just them complaining about the attorneys making these statements. And the judicial rule is that attorneys aren't supposed to make statements that could influence the proceedings or, prejudice the proceedings. But I think the easiest defense to this is that the jurors aren't supposed to be watching anything. So anything the attorneys say in these interviews, I mean, it's presumed that the jurors aren't watching it, right? So I don't know. It seems like out of all the things going on, that'll be the least of the judge's concerns, but we'll see. We've got the motions for mistrial, and Young Thug did file a motion for bond and a motion for mistrial. Bruce Harvey, attorney for Quamarvius Nichols, has his motion for mistrial, and Deamonte Kendrick has his motion for mistrial. And Max Shard, on behalf of Shannon Stillwell, actually filed a motion for fair and constitutional trial. Because remember, as people have watched my interview with Max Shard, is a mistrial actually in the defendant's best interest? And in his motion says that he only wants a mistrial if double jeopardy attaches. And that would mean they can't be retried again. I mean, obviously that would be everyone's best bet, or best hope is just if this case completely goes away. So somebody asked if Doug is going to come on. He not this afternoon. He's actually we're both MLB fans, so I can support this, but he's at a Braves game. And but tomorrow we'll have I'll set it up and have more time tomorrow. So I'm going to do Doug Weinstein, and then I'm also going to do an update on Boozy's case. My friend Megan Blanco, his attorney, who I know from other cases too, is going to talk. And then I'm also going to have Bryson Paul give us an update on the YNW Melly case. So that'll be tomorrow, but I figured I'd just do an update real quick and bring up the motions here. But for you guys who are on TikTok, I'm going to bring up the actual motions on YouTube and share them on the screen. So if you guys want to subscribe to me on there, it's just Meghann Cuniff, my name. I'm almost at 20,000 subscribers. If I get enough of you head over there, we might be able to break it. I'm only like 15 away, but yes, Jeffrey Williams motion for bond and brief of support of pre-verdict bond. Because remember, like I said last week, Marquavius Huey first filed for bond, and under what's known in the trial as the Harvey rule, named for Bruce Harvey, technically all other defendants join in on any motion that gets filed unless they specifically opt out. But for something like bond and mistrial, I figured they would all want to file their own arguments, or most of them would, and that's what's going on now. So here's the let me bring up the really, like I said, probably the most interesting one, the kind of the juicy one, because all these are expected. Mistrial, bond. I mean, the big question is just going to be next Tuesday whether she already grants them. But I would not have predicted that prosecutors would file a motion complaining about the interviews, like basically asking for a gag order on the attorneys. So, I mean, it doesn't surprise me that they did, but that's probably the most like I said, it's probably the least consequential in terms of the actual trial, substance of the trial, but it's pretty interesting. This is it. Right here, but it states motion to restrict extrajudicial statements, and they actually include as exhibits my interviews and the interviews that infamous Sylvia did, making her even more infamous. But and then, like I said, they even cited just some basic statements that Brian Steele made, like a written statement that was emailed to attorneys that's not even him sitting for an interview. So I'm not sure how. I think the chances of this being granted are none, but it's interesting. Let's see here. It says Defendant Williams' counsel, attorney Brian Steele and Keith Adams, Defendant Kendrick's counsel, attorney Doug Weinstein, and Defendant Stillwell's counsel, attorney Max Shard, have all made extrajudicial statements to the media explicitly discussing the case in violation of 3.16. Again, prosecutors in the YSL trial filed a motion today asking the judge to basically issue a gag order on the defense team. And they're citing the recent interviews that the lawyers have done, like Max Shard and Doug Weinstein's interviews with myself and infamous Sylvia. And they're saying that the judge basically needs to put a stop to this. And it says, the state moves this honorable court to instruct the defense to refrain from making extrajudicial statements about this case moving forward. So they stopped short of just asking for a straight up gag order, but well, I guess that basically would be a gag order in effect if they did. But excuse me, I had the wrong document on screen here. You fix that here. Here it is. Yeah, here it is. State's motion to restrict extrajudicial statements. It says defense counsel have made numerous extrajudicial statements explicitly about this case, while a jury is sworn and seated during the state's case in chief. Like I said, who knows what the chances of this actually being granted are. I mean, it seems like the judge has bigger things to worry about. And they don't really give any examples about how this is, specifically a problem. It's just kind of warning about things, but we'll see here. So again, many motions filed today, mistrial, bond, but probably the most unexpected is this motion from prosecutors basically whining about the defense attorney's interviews and asking the judge to restrict extrajudicial statements. It's 10 pages here, and it cites statements by Brian Steele, which is just, like I said, a statement that he emailed, that was emailed to media outlets. It's not him talking publicly. But then also Keith Adams, which I think infamous Sylvia has the clip of him just talking to attorneys or talking to reporters outside of court. But and then Kendrick's counsel, Doug Weinstein, and Max Shard, their interviews too. So why this is that big of a problem, I don't know. It seems like they're just kind of whining about it, but we'll get into why they think this is such an issue. And they're, of course, citing a judicial rule, Georgia judicial rule, that says attorneys shouldn't make extrajudicial statements that could influence the proceeding. But I think the attorneys would just say that the jurors are under instruction, under order, not to talk about or not to watch any of this stuff. So anything they say in these interviews shouldn't be seen as an attempt to influence anything when, the jurors aren't supposed to be watching. So I see somebody, Shay on TikTok says, I'm always keeping them in the loop. Yes, definitely. But here's the statement from Brian Steele. So I think the judges, especially if this is it from Brian Steele, I mean, to say that he can't say stuff like this, what is so bad about this? And he's not saying anything about the prosecutors. He's, he is. He's saying they've run afoul of their duties under the law, but he's not. I mean, is that a personal attack on them? I mean, that's kind of been the debate in trial. Is Love says that she's under personal attack, and it's like, okay, is calling a prosecutor unethical and saying they're not doing their job? I mean, if I was a prosecutor and somebody said that to me, I would take that personally, but I don't. I don't know. It's like so we just can't criticize people in the way they do their jobs, But yeah, Brian Steele's statement. This is what they take issue with. It says Jeffrey Williams is innocent of the charges brought in this indictment, and to clear his name, he sought a speedy trial, one in which he would receive the constitutional guarantees of a fair trial with an impartial judge presiding and ethical prosecutors following the law. Sadly, Judge Glanville and the prosecutors have run afoul of their duties under of the law. Mr. Williams is grateful that the reviewing court agreed with him and entered the order recusing and disqualifying Judge Glanville from presiding over Mr. Williams' case. We look forward to proceeding with a trial judge who will fairly and faithfully follow the law. Now, remember, the Judge Krause, when she decided to recuse Judge Glanville, actually explicitly said that she generally agreed with Judge Glanville about the propriety of the ex parte meeting. This ex parte meeting that spurred all this, the June 10th meeting that everyone said, the defense is saying was misconduct, etc. She did not agree with that. That is not why Judge Glanville was recused. He was recused because Georgia state case law is really clear that when judges are hit with recusal motions, they're not supposed to publicly defend themselves. And anyone who remembers how Judge Glanville handled this is he made a lot of statements on the record talking about how the ex parte was proper and this and that. So that was the basis for recusal. And some of the motions that have been filed today, actually last week, Brian Steele, Young Thug's lawyer, filed a motion asking the new judge, Judge Whitaker, to reconsider those rulings. He doesn't want her to reconsider the overall order recusing Judge Glanville, but he wants her to reconsider Judge Krause's finding that the ex parte, that there wasn't anything improper about it. And also there's a line in Judge Krause's order that says something like, divorce from hyperbole. Basically, she says that Brian Steele had a lot of hyperbole in his motion. So he wants Judge Whitaker to take that back. And Doug Weinstein, the attorney for Deamonte Kendrick, who we've heard about, has filed a similar motion asking Judge Krause to declare, his mistrial motion is based on the argument that the ex parte is unfair or was improper. Excuse me. So that's going to be, Brian Steele's motion. I think it's going to be an easy way out for Judge Whitaker to just say that there's no reason for her to reconsider anything Judge Krause said, that Judge Krause already addressed that and that she's not going to go and reconsider that. But it also kind of opens the door for Judge Whitaker to offer her own analysis of the ex parte. I think she's just going to stick safely with, Judge Krause already decided that issue. There's no legal reason for me to go back. But she could say, Judge Krause already decided that issue and I agree with her. It just kind of opens the door for her to really piss the defense off by reiterating that she thinks the ex parte, it wasn't that bad. But I think she'll probably kind of steer clear from that and just say that there's no legal reason for her to reconsider a ruling by Judge Krause like that. But we'll see. That's a pretty significant one. And like I was saying last week, that's the one that really kind of is a foundational one for the other ones, like a motion for mistrial, a motion to recuse the prosecutors, because without a misconduct finding about the ex parte and some kind of ruling against the prosecutors on that, it's going to be hard to support for at least Judge Whitaker to support any kind of recusal or mistrial with double jeopardy. But I think Bruce Harvey's, I mean, all the motions bring up their own arguments for mistrial or as Max Shard said, a fair constitutional trial. But Bruce Harvey, who's the most experienced attorney in the courtroom, like by far, including the judge, like when Judge Glanville has been on the bench since 2005, but Bruce Harvey's been an attorney since, the 70s, and he's done a lot of really big cases in the state of Georgia and the South too. He's always been, kind of a legend. So, although that word is overused, but he just talks about, and this is what I always thought with the idea of a mistrial, the substitution of a trial judge. He is saying is just grounds in itself for a mistrial here, and that's what was so interesting about here. Gotta readjust here. I think I lost connection to the thing. Bring it up again. I'm on YouTube too, if you guys want to actually see the documents. Get them up here. Here it is. Yeah, this is Bruce Harvey. He represents Quamarvius Nichols, but he says, Mr. Nichols moves for a mistrial and objects to mid-trial substitution of the trial judge because here, for a judge to be substituted after 19 months, including 6 months of testimony and the admission of evidence, prejudices the defendant's right to a fair trial under the 6th and 14th Amendment to the United States Constitution, as well as the I'm going to butcher that word, as well as the Constitution of the state of Georgia. Further, Mr. Nichols moves for mistrial and objects to mid-trial substitution of the trial judge because the current presiding judge was not the judge during the last 19 months of trial. When, for example, Mr. Nichols moves for a directed verdict, this court will be unable to adequately evaluate the entirety of the prior proceedings in order to rule on the request. Of the 19 months of trial, over 6 months of testimony has been for which this court was not present and therefore cannot base its decision on what has occurred during trial. Yeah, I mean, the idea that she's just going to be able to catch up through the transcripts or something into this just seems weird. And just the length of this, I mean, it seems unprecedented. But like I said, California has a policy that says, like, if a judge dies during trial, God forbid, as Brian Steele would say, another judge can take over mid-trial, and the trial there's no mistrial. So there is some precedent for this, like nationwide. But this is an exceptional case in terms of its length. I mean, we were usually talking like couple week trials or maybe a month trial, but to have a trial this long, it's like, wow. During the trial, before this court became the presiding court, Glanville made several decisions noting that he would revisit his rulings as trial proceeded. That's true. He was always doing that. And he would say that all the time, that, one great thing is I can change my rulings if I want to, that kind of thing. So he'd always kind of left the door open on that. So to have another judge come in and take over, that just kind of goes out the window. It says these contingent rulings covered several aspects of the tentative admissibility of evidence. Given the fact that the current court is unfamiliar with over 6 months worth of testimony, arguments by the parties, motions by the parties, and contingent rulings, this court could not possibly make decisions based on what has occurred, which the court was not privy to, nor has reviewed the record. Yeah. Mr. Nichols further moves for mistrial and objects to mid-trial substitution of the trial judge because Nichols specifically on several occasions during trial moved the court to give curative Rule 105 instructions. That's like an extra instruction to the jury saying, hey, something just occurred. We need to let you know about it or something like that. The court denied each request to give such instruction at the time, but indicated it may be necessary to give it at a later time or at the end of the trial. Yeah, this was just bad trial management by Glanville. But Mr. Nichols also moved the court for severance on multiple occasions, which the court denied at the time, but agreed that a time may come that the issue would need to be revisited. This court would now need the benefit of the 6 months worth of previous testimony to adequately and fairly make decisions regarding whether instruction and or severance is warranted. Given the court is unfamiliar with the trial proceedings, as is indicated that it did not intend on familiarizing itself with the trial proceedings. That's an important note. What's his footnote there? It's Nichols would contend that such a task would be impossible at this point. Yeah, I mean, exactly. When she's got this to preside over, how she's going to start reading the transcript, and reading those transcripts is helpful to some point, but you can't expect to get a complete feel for the trial by doing that. So let me see here. Yeah, I mean, it honestly seems like the best argument for a mistrial that I've read so far. But this court has missed crucial proceedings necessary to make fair and well-rounded rulings and to properly instruct the jury both during and at the conclusion of trial. Mr. Nichols moves for mistrial and objects to mid-trial substitution of the trial judge because this court has indicated that it does not intend on reviewing the complete record, including trial proceedings and litigation that have already occurred. For this court to step into a 19-month ongoing trial in which over 100 witnesses have already testified means that this court is proceeding with trial and unable to assess core trial functions, such as the credibility of the witnesses that have already testified. The lack of a trial court being personally familiar with the record but presiding over the continuation of this trial, making decisions regarding trial, and instructing the jury violates Nichols' right to due process and a fair trial as guaranteed by our Constitution. Again, for people tuning in, I'm going over the new motions filed in the YSL trial. We had a slew of them, and this is Bruce Harvey's motion for mistrial on behalf of Quamarvius Nichols. And Bruce Harvey's the guy, we don't hear from him very much. I mean, gosh, have we ever even seen him at the lectern? He's got the long ponytail, but he stands up in the back, and he works with Nicole Westmoreland, who in the beginning of trial, she did some exams. But one thing to remember is that Bruce Harvey is the only defense attorney who reserved his right to give an opening statement. So if this trial ever gets past the prosecution's case and it's time for the defense to present, we're going to hear from Bruce Harvey. He's going to give an opening statement. But if these guys have their way, the trial's not going to proceed. Like I said, this is Bruce Harvey's motion for mistrial just based on the substitution of the judge and the sheer length of the trial. The idea that they're going to be able to, that Judge Whitaker would be able to keep up on all this testimony that's already happened and make informed decisions moving forward based on it. Seems like a pretty good argument, but I don't know. We'll see. I mean, anyone who watched the hearing and saw the clips of her, she is completely aware of everything that, well, not everything that's gone on, but she's completely aware that she's missed like 19 months of all this stuff, and she still seemed, y'all, I'm moving forward. So yeah. And then he's also, not just because of the substitution of the judge, but Harvey's saying another reason for mistrial is the trial has been suspended for over a month, and jurors cannot reasonably be expected to just pick up where they left off with their memories and observations intact. Furthermore, a mid-trial substituted judge cannot adequately instruct the jury regarding previous proceedings, which the judge is unfamiliar with. Further, Nichols reiterates and realleges his request for severance and incorporates his previous arguments that an enormous amount of prejudicial spillover has already occurred and no jury could be expected to compartmentalize the evidence as it relates to the separate defendants and charges. Yeah, that's always just been the fundamental problem with this case. And I've always thought from the beginning that when Harvey, he makes a standing objection for severance and instruction regarding co-conspirator testimony. That always seems like their best argument on appeal, but what do I know? I mean, we'll see if it ever even gets there. So again, let me pull up the list here. I made a list of what we've got. Thanks for tuning in, guys. Hit the like button. Let everybody know we're here. Send me some diamonds on TikTok if you can. But if you guys want to see the documents, head on over to YouTube. But this is what a quick list. It's not totally exhaustive, but this is what I've come up with. Prosecutors in the YSL trial have moved to restrict public statements, and they're complaining about the interviews the defense attorneys have done with me and also infamous Sylvia. And then they're just complaining about some pretty basic and common statements, like the statement that Brian Steele issued after the recusal. But and they also want to exclude victim character evidence, alleged victim character evidence about Donovan Thomas. Max Shard, Shannon Stillwell's lawyer, has a motion to reconsider Glanville's ruling regarding the admissibility of Garlington hearsay. Because remember, and this was basically a huge part of the point of Copeland even testifying, is in Copeland's 2015 interviews, this is Woody, he talked about how after Donovan Thomas's murder, Lil D and Shannon Stillwell, like he picked them up somewhere, they got in a car, and he claimed at the time that Little D said something about Donovan Thomas's murder, like basically confessed, said that they did it. Problem is, anyone who saw Woody's interviews, he's not copying to any of that now. He's just made blanket statements like, I was lying, you know, he won't, he won't admit to any of that now. So in the interviews, the 2015 interviews that they want to play to try to impeach his testimony, previous testimony, they want to play those clips. But the argument has always been that it's not really proper impeachment material because he hasn't denied saying that stuff. He's just said that it wasn't true and kind of made statement after statement that he was just lying and trying to get out of it. So the argument from Shard in his motion to reconsider is that Glanville never should have allowed those in as questioning. And that's big. I mean, if for some reason the Judge Whitaker decides to change that and not allow prosecutors to bring in those statements, it would be a pretty significant ruling. But this is like the first chance for her to show whether she's willing to go back and really revisit rulings by Glanville. And it's not like these are like way old rulings. This is something that was pretty new, and it's about a witness that theoretically, if she doesn't call a mistrial, Woody's going to be back on the stand. So this is going to be an issue for her to deal with it. So like of anything to ask her to reconsider, stuff regarding Woody's testimony seems like it has the better chance. So Trishelle, Numa, I see your comment. I see you say you love my coverage of the case. Thank you. I'm awesome. Thank you. But yeah, for people who are just tuning in, no trial this week. If anybody's looking for court proceedings, they will be back on Tuesday, July 30th. The judge gave everybody this week to file their motions, and then Friday, the end of Friday, prosecutors are supposed to respond to the defense motions, and then expect we're going to see some defense response to the prosecution's motions. But most of these are to be expected. I mean, the hearsay, Max Shard asking the judge to revisit her ruling regarding that, I didn't completely expect that. But mistrial, bail, I mean, those are all totally expected. But the one that's kind of funny is, like I said, prosecutors are complaining about the interviews that the defense attorneys have done. Let me bring up their full motion. They bring up Brian Steele's statement. There's just one statement that he made that is actually pretty common for defense attorneys to do. And then they've cited Max Shard's interviews with me and Sylvia, and then also Doug Weinstein's. But here's the motion to exclude extrajudicial statements. The thing is, they don't even really get into why exactly this is a problem. It's like, okay, so the jury isn't supposed to be watching stuff online. And I mean, if the jury is watching stuff online and seeing these interviews, they have a way bigger problem than just the attorneys need to shut up. I mean, they'd have to declare a mistrial if they thought that any of the attorneys or any of the jurors had like watched any of these full interviews, right? So under the assumption that the jurors aren't watching the interviews, I don't know how they can make a finding that the attorneys are making public statements like with the intent to influence proceedings or be prejudicial to the proceedings. But it says 4 of these interviews have been 25, 33, 43, and 107 minutes in length. That's me and Max Shard at the 107 minutes. Like that, we had a good vibe going on in that interview. But the statements include, among other things, the attorney's views and opinions about the case itself, opposing counsel, the now former judge, the jury, the outcome, and the guilt or innocence of specific defendants. And pursuant to OCGA 15-1-3-4, courts have the power to control in the furtherance of justice the conduct of its officers and all other persons connected with the judicial proceeding before it in every matter appertaining thereto. So I don't know. Is the judge going to see this as a problem? They don't name any specific statements and say specifically why, like they shouldn't have said this and why this is a threat to the integrity of the trial. I mean, they're basically just complaining about it. But when you look the exhibits, this is Brian Steele's statement regarding the recusal order. I read that earlier. Young Thug's attorney speaks out on Glanville. I think this is on Sylvia's page. I remember seeing that. That was like right outside the courthouse, which is another thing that's completely common that, you know, attorneys generally don't talk. Like we don't really see Keith. We haven't seen Keith Adams or Brian Steele sit for interviews at all. But I think Keith Adams just walked outside the courthouse and reporters were there and they, you know, put the microphone in. He just said a few things real quick and it's online. The Associated Press reached out to Glanville and to a lawyer for Young Thug seeking comment on Monday's ruling. This is the recusal order. And Doug Weinstein issued a statement. He said, while I respect Chief Judge Glanville and his service to this community and the country, he simply became biased over the course of this case. He added that he looks forward to trying the case, quote, before an unbiased judge, but said the only just outcome at this point is a mistrial and bond for Kendrick. I mean, I just feel like I said, if the idea that is jurors are going to see these statements and somehow be influenced, jurors are not supposed to be reading any of this stuff anyway. And if they are, I think the problem is much bigger than just the attorneys need to shut up, you know? And I don't see this actually being passed, but who knows? Oh, and here's us. Judge Glanville recused. This is the live interview discussing Glanville. And they have their favorite excerpts. There's like a 17. I don't want to give them the. Complete interview, 146, exhibit, Max Shard. And then debrief, another interview with Weinstein. And this is them saying that they gave all the other attorneys a heads up that they were going to file this. So it'll be interesting to see the defense's response to that. Like I said, they've got until Friday to respond. Same with prosecutors to. Let's see, what else do we got here? Yeah, and I put together a list here on everything. Thanks for tuning in. Here, let me bring up the list I made. Yeah, the prosecutors filed to restrict the defense public statements. That's what we just went over. Max and exclude victim character evidence about Donovan Thomas. And this gets into the alternative theory that Woody killed Donovan Thomas. Max Shard filed to reconsider the Judge Glanville's ruling regarding the admissibility of statements that Little D supposedly made to Woody. And this is from the interviews that Woody gave in 2015, because Woody has not backed up those statements on the stand. He said in 2015 that Little D got in the car and made statements basically confessing to killing Donovan Thomas. And Glanville was going to allow those in the examination of Woody as co-conspirator statements. But the argument is that they're not actually co-conspirator statements, because just a confession or a supposed confession is not furthering a conspiracy. It's like you need to be saying something else or something more than just confessing to a crime to be somehow furthering a conspiracy. So that's kind of the first substantial chance for the judge to change a ruling that Glanville made. And it's for a witness that she's currently going to have to be dealing with. So that'll be interesting to see. And then Max Shard did not file for mistrial, but he filed for fair and constitutional trial, because he's saying he doesn't want a mistrial unless double jeopardy attaches, which would mean they can't be retried. Doug Weinstein for Deamonte Kendrick filed for mistrial and bail, and Brian Steele and for Young Thug filed the motion to reconsider Judge Krause's ruling on the ex parte, which is important because remember, Judge Krause said that she generally agreed with Glanville's assessment of the propriety of the ex parte. And she also had a line in there that said divorce from the hyperbole when she was describing Brian Steele's motion. So she basically said that Brian Steele's motion had hyperbole in it. So he wants Judge Whitaker to rescind those findings from Judge Krause, which I think is unlikely, just because Judge Whitaker isn't going to feel the need to or feel like she can reconsider another ruling like that. But it'll be interesting, and it certainly opens the door for more analysis and debate about the infamous June 10th meeting. But and then he's also got that motion that was filed a while back to disqualify DAs Love and Hilton. He's got the motion to strike all of Woody's testimony, because remember, we've heard so much about how in Georgia, if a judge is recused, anything that happened after if the trial proceeds after they should have been recused, it's whatever happened is invalid. So here the argument is that that's all of Woody's testimony. So we've got the motion in to strike all of Woody's testimony. And of course, that gets into the arguments for a mistrial. We've got Keratin Matthews on behalf of Marquavius Huey requested the bail, which is also a motion for mistrial. But then Bruce Harvey has requested severance and mistrial. And we saw a lot of that. But that here, there's Deamonte Kendrick. But again, can I go through a rundown here? But again, the lots of new motions filed today in the YSL trial. Deamonte Kendrick, who's right here, his lawyers, Doug Weinstein, who we've heard from, has requested bail, and they've also requested a mistrial. And then, interestingly, prosecutors have actually moved to have Judge Whitaker tell the defense they can no longer make public statements. They're citing all the interviews that Doug Weinstein, Max Shard, Keith Adams have done with me, Sylvia, different public statements that they've made, in saying that this violates Georgia's judicial rules regarding extrajudicial statements being made, but particularly in criminal cases, they say it's a problem. They don't really get into many details about specific statements they have issue with or why these statements are a problem, but they're basically asking for a blanket gag order that would restrict any public statements moving forward. So that was among the motions filed today. I expect the defense will file a response to this by the deadline end of Friday in Atlanta. And then again, they are back in court on Tuesday, July 30th to start going over all this stuff. 8:45 a.m., as Judge Whitaker made clear, that's 5:45 a.m. here in California. But she's got a lot to really decide. And really, while the motion complaining about the public statements is one of the more interesting ones, it's probably the least substantial in terms of what will actually affect the trial. I mean, we've got some motions for mistrial that are substantial, also motions for bail. We've got the motion that was filed last week for Marquavius Huey, and then we've got Deamonte Kendrick's motion for bail, and then Brian Steele and Keith Adams also filed a motion for bail on behalf of Young Thug. So we've got a few things to really look into here. And the judge, I mean, this is going to be the first real test for the judge come Tuesday morning, is how is she going to respond to some of this stuff? It's such a big question of, is she going to be willing to revisit that ex parte meeting on June 10th that, remember, is what started all of the recusal motions, but it's actually not the basis for the judge's recusal. The Judge Krause, when she recused Judge Glanville, even said in there that she generally agreed with his assessment of the ex parte meeting. But her problem was, and Glanville's problem started with when he was defending himself against these recusal motions. And this wasn't even an argument that was raised in the recusal motions against him. The judge went out and found her own reason to recuse him. But case law in Georgia is pretty clear that judges are not supposed to defend themselves when a recusal motion is filed, a public defense. And one case even says that the public defense against the recusal can then become the basis for recusal. So that's what happened to Judge Glanville. So overall, the recusal was a huge win for the defense, but there's stuff in that ruling that isn't helpful for them, in that Judge Krause says that she generally agrees with the propriety of the June 10th. And then she includes a line like divorce from hyperbole when she's describing Brian Steele's motion for recusal. So Brian Steele has asked Judge Whitaker, the new judge on the case, to reconsider those rulings by Judge Krause. So those are, that's the biggest. Obviously the mistrial would be a bigger deal, but if Brian Steele can get Judge Whitaker to reconsider those rulings and make a finding that the ex parte was wrong, and that the prosecutors were wrong to conduct this too, that increases the chances that, okay, there's a prosecutorial misconduct finding. Could there be a double jeopardy finding if there's a mistrial? That's it. Kind of lays the foundation for everything else. Like I said, it's hard to say what she's going to do, but I just think with Judge Krause being the judge that made those rulings, and she not really being dirtied up in this case at all, like there's no reason to question, her rulings on that I don't know if Judge Whitaker is going to feel comfortable like going back and redoing that decision. But the one other test that Max Shard is asking for here is for reconsideration of the ruling regarding the admissibility of hearsay from Little D regarding Donovan Thomas's murder. Because remember, a big part of why they called Woody to the stand is he just sang like a canary back in 2015 and really gave all this stuff that prosecutors were kind of just treating as the gospel, and just counting on the fact that Woody was going to get up on the stand and just say all that kind of stuff again. And back in 2015, Woody told the cops that Little D and Shannon had gotten into a car with him after Donovan Thomas's murder, and that Little D had said something that basically confessed to Donovan Thomas's murder. But the problem is, I mean, anyone who's seen Woody's interviews knows that he's not backing up those statements now, and he's just saying that he was lying and he was doing anything he could to get out of it. So Max Shard's argument is in this new motion is that the Glanville was wrong to say that those interviews from 2015 could be admitted in court, and that prosecutors could ask Woody about it, because Glanville had said that they were part of a co-conspirator statement, that they're hearsay statements under co-conspirator rule. But apparently the case law on co-conspirator hearsay is it has to be more than just, I did it. It has to be something that actually furthers the conspiracy. That Little D supposedly getting in the car and confessing isn't anything that they did to like further the conspiracy of murder or YSL or RICO or anything like that. Yeah, somebody said she recused him for public trust of the case. But yeah, that's what she said about the about the public statements, because it was based on the public statements that the judge made, but she cited, public trust in the judiciary, because she even said, she had no doubt that he could consider, he could continue presiding over this fairly. But when you look at the Georgia case law on judge recusal, it is really clear, and there's some past cases where judges have really gotten in trouble for defending themselves, for publicly defending themselves, and that's exactly what Judge Glanville did. Like, if you go back and look at the video from July 1st when he sent them to another. When he sent them to another judge, the headline on my video, I made it, Judge Glanville defends ex parte, because that seemed like a pretty accurate description of what he was doing. So it'll be interesting to see what Whitaker does in terms of the ex parte. She'll be pretty safe to just stay away from offering her own assessment of it and just saying that, look, another judge has already decided that, we don't need to revisit that. But these requests also kind of open the door for her to possibly really piss the defense off by saying that she doesn't see a problem with it either. I think she's smart enough to just stay away from that. If she doesn't need to say anything like that, why do it? But here, let's bring up, and I don't know if you guys are on Twitter, but if you're looking for a good way to just stay up with the documents, Thugger Daily, who's kind of risen to prominence on here, he and Joseph posted a lot of I think all of them, the documents today. But remember, I was liking his interviews where he's got a corporate job where, and that's the way to fund good journalism, is we all just get corporate desk jobs where we don't actually have to do anything, and we can just be on our computer doing journalism, and the corporate desk jobs will actually just pay for it, and we can all just have fun on Twitter all day and not worry about the fact that it doesn't pay. But one thing I do have to say, a lot of the talk about corruption on here kind of just reveals that the people who are saying, I mean, and you can agree, you can disagree with the judge's ruling and stuff, but saying that this stuff is all corrupt, I mean, is there any kind of quid pro quo agreement here? I mean, the defense attorneys, I don't think, are even going that far to say that, but it just kind of reveals that a lot of people actually haven't covered a lot of public corruption cases. So somebody asked what a corporate desk job is. It's just some monkey, desk job where you're just I mean, they're out there. Corporations have tons of people, the pods and stuff where they all work. You're just on the computer all day, various administrative tasks. But a lot of those things you have a lot of downtime because the tasks aren't very involved and stuff. But I love it. If you guys, I mean, Thugger Daily, I think Complex said, does he live in Dallas or something? He wants to remain anonymous. And he says there are other reasons besides just the fact that his work wouldn't be happy to know that he was, watching trials and tweeting on social media all day. But he says there are other reasons for staying anonymous. But I'm saying that's the way to fund journalism, is we all just get different corporate jobs that actually give us salaries and health benefits. And then we can just, in our huge amount of downtime in those jobs, we can cover trials all day. This is the Donovan Thomas stuff. She brought this up, Adrienne Love did, during trial with Judge Glanville, when and there actually it was Hilton who was making the argument too, saying that stuff about things that he'd done or something kind of perpetuating some rivalry with Woody or something weren't relevant, and they were saying that the defense can't present an alternate theory that Woody was the killer, even though they already did. I mean, they said that in their opening statement, so that they shouldn't be allowed to present any of this stuff because it's basically just bad character evidence. But one argument against that Brian Steele made is that the prosecutors have kind of brought Donovan Thomas's character into brought his character into question by I mean, in the opening statement, they were talking about how he was, buying haircuts for little kids, even though that didn't really turn out to be the case in the testimony. But the argument on that was that, the prosecutors were kind of lionizing him, so they should be able to tell the truth about him there. But those are the two main. I would kind of expect more from the defense, at least a couple more filings, but it's already late enough in Atlanta that unless I missed a couple, I think it's the motion complaining about the interviews, and then the motion to exclude the character evidence testimony about Donovan Thomas. But I think it's debatable, but whether it's even character evidence here. But anyway, thank you guys all for tuning in. I'm going to do another one tomorrow. We'll have, thank you for the roses, Candace. I see those on TikTok. We'll have Deamonte, Kendrick's lawyer, Doug Weinstein, and to talk about the motions that he filed. But this is Young Thug's motion for bond. And we've got several motions for bond in now. It'll be interesting to see in what order the judge decides to take these. But remember, 8:45 a.m. on Tuesday, and that's 8:45 a.m. in Atlanta. So it's 5:45 a.m. here in California. So I've been actually kind of trying to get ready for that. I'm kind of trying to take it easy this week, knowing that it's going to be a big life change here. But yeah, somebody wants a quick recap, but let me pull this up here. Oh yeah. But yeah, for those just tuning in, this was the filing day for the motions, any motions that they want Judge Whitaker to consider starting next Tuesday when they're all back in court in Atlanta. And the big ones are, of course, the motions for mistrial and the motions for bond. Deamonte Kendrick, who's on the screen here, he filed for bond. I thought Bruce Harvey filed a good motion for mistrial. He's Quamarvius Nichols' attorney. About that's just based on the fact that having a judge come into a trial 19 months in and 6 months into testimony is just it's impossible to think that they're going to be able to make informed decisions about the previous proceedings as they move forward. So I mean, it's hard to argue with that one, but I'm sure they will. And of course, it's not like the judge, when she was in court last week, it's not like she didn't know all that, and she was making it pretty clear that she wants to move forward. But I mean, just when you read the argument here, it's like, yeah, that seems like a compelling one. But yeah, so prosecutors moved to restrict public statements about the attorneys. They've been complaining about the interviews that like Max Shard and Doug Weinstein have done. They want to exclude victim character evidence about Donovan Thomas. So those are like the questions to Woody regarding that kind of imply motive for him to kill Donovan Thomas, like things that Donovan Thomas was doing. We've heard various discussions about that. Pretty substantive one from Max Shard asks Judge Whitaker to reconsider Glanville's ruling regarding the admissibility of statements that Woody made in 2015 regarding stuff that little D supposedly told him. In 2015, when Woody sat for the interviews with police, he said that little D had gotten into the car with him after Donovan Thomas's murder and basically confessed. And because when Woody got on the stand, he didn't back up any of that. As somebody just said, yeah, Woody don't recall. So to try to it's hard to say it's impeachment, because defense's whole argument is it's not impeachment, because it's not like Woody said, no, I never said that. So they need to show the statement showing him that he did say that. He's just saying everything I said in 2015 was a lie. But Glanville was going to allow prosecutors to play those statements from 2015 and ask Woody about it, which Max Shard is now asking to reconsider. So that'll be a pretty interesting one to see whether the judge is willing to reconsider a ruling. But this one, I mean, it makes sense that that would be the one that they ask for, because that's not like a ruling for a witness 6 months ago. This is a witness that she is going to have to deal with herself on the stand. But and then again, the big question is, if she doesn't call a mistrial and they do move forward with Woody's testimony, where in Woody's testimony are they going to be? Are they going to start over? Is she going to tell everyone that the direct exam that they've had of Woody so far is invalid because it happened after Judge Glanville was supposed to be recused? They're just like all sorts of questions on that. But anyway, thank you guys so much for tuning in. I'm going to do another one tomorrow with Doug Weinstein, and also hopefully talk about some other cases, Boozie's gun dismissal. And then I was going to have Bryson Paul on to talk about the Melly case. I know everybody's always asking about the Melly case, and he's been covering it a lot longer than I have. So that would be informative to have him up here. But again, we've got bond motions in for Young Thug and his Deamonte, Kendrick, Marquavius Huey. I mean, I think, and they're all kind of automatically in on each other's motions, but there are different arguments being made. But yeah. So anyway, if you guys have any questions, get them in. But again, Friday is when the defense and everyone is going to respond to this stuff. Prosecutors will respond to all the defense motions, and defense will respond to the prosecutor's motions. It's particularly interested to see the response to the argument about the media interviews. Here, and there's Bruce Harvey. He doesn't specifically ask for a mistrial with prejudice, although yeah, we'll see. She's got so much to decide. It's going to be pretty interesting to just see. First of all, I mean, what is she even going to do first? Monday morning, or Tuesday morning, excuse me. Not Monday. Tuesday, July 30th at 8:45. They will be back. So thank you guys so much for tuning in. Check out tomorrow. I think it's going to be tomorrow at like 3 p.m. Pacific, 6 p.m. Eastern time. We'll go over the motions again with Weinstein and get into some other cases here. I saw somebody saying they wish we'd just stick to YSL. It's like, well, it's pretty much what I've done, but there's some other state cases that I need to keep you guys informed on that we need to do some videos on, because yeah. I'm not sure if she's going to grant bond. I mean, I feel like Bruce Harvey's argument for mistrial is like the most compelling. Just how can a new judge take over a case like this? But I mean, she knew all that going in there, and the way she talked last week, I mean, it definitely sounds like she wants to move forward. So I don't know. We'll see. But I think it's unlikely, but who knows? We haven't really seen much of her in action yet. So we'll have to see. But thank you guys so much for tuning in again, and I will see you guys later. Thank you.